of California. I'm Dr. Ron Lewis, and I'll be chairing Panel A today. The first item of business is that during this open session we call for a roll to establish a quorum, so if we could do that now. And also make sure your names are visible to the court reporter, and we'll, whatever you need to do for spelling, whatever, okay?
Dr. Hawkins?
Here.
Mr. Warmoth?
Here.
Ms. Wright?
Here.
Dr. Yip?
Here.
Ms. Sutton-Wells?
Here.
Dr. Lewis?
Present.
We have a quorum.
Good, we've established a quorum. So the second item of business is the oral argument on non-adopted proposed decision for Dr. Mark Altchek. And I will turn this meeting now over to the ALJ.
All right, good morning. We are on the record in the matter of the accusation against Mark Altchek, MD. This matter has been assigned Medical Board Case Number 800-2015-012478 and Office of Administrative Hearings Case Number 2018-06-1236. Today's date is July 26, 2018. My name is Jill Schlickman. I'm an administrative law judge with the Office of Administrative Hearings, and today I have been assigned to preside over this proceeding. At this time, I will take the appearances for the record, starting with the Attorney General's office.
Good morning, Your Honor. Deputy Attorney General Lawrence Mercer appearing for the complainant.
All right.
Gary Thielander, attorney for the complainant and respondent to this action. Mark Altchek, who's seated to my left.
Thank you. All right. In making your presentation, please bear in mind that the board members have read your written argument and that the argument may be based only on the existing record. Respondent will be allowed 15 minutes for opening argument. Mr. Mercer will then have 15 minutes for complainant's opening argument, and each party will have 5 minutes for closing argument. After the hearing, the board will meet in closed session for deliberations. The board's decision will not be announced today. A written decision will be mailed to you as soon as possible. At this time, I'm going to ask Dr. Altchek to raise his right hand to be sworn. Do you solemnly swear or affirm under penalty of perjury that your testimony in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. All right. I understand from talking to the parties before the hearing that Dr. Altchek plans to make the opening argument rather than have his attorney make that. Is that correct?
Yes.
And you'd like me to interrupt you to let you know when you have 3 minutes left and 1 minute left. Okay. All right. Okay, Dr. Altchek, go ahead.
Thank you. Administrative Law Judge Jill Schlickman, Dr. Ronald Lewis, and the members of Panel A, the many other important people here, and everyone really. I am well aware that I am not a perfect doctor, of course, and that my charting needs improvement. I ask that you give me an opportunity to improve my charting using the SOAP format. But I want to say a few things about the hearing, which I think was below the minimum standards. On November 4th, 2017, 73 days before the January 2018 hearing, while walking rapidly down a steep hill in San Francisco, I had a bad fall on the concrete. I had a concussion, a large and deep abrasion and swelling of my forehead, a swollen nose, and swelling and soft tissue damage of my left knee. 2 days later, an MRI showed a fractured nose. My attorney, Mark Garver, at the time, requested a continuance, which was denied after 5 to 7 days by ALJ Administrative Law Judge Juliet Cox. I believe that was elder abuse. I was 67.3, and I didn't need the stress while trying to heal. Not getting the continuance hampered my ability to mount anything close to an optimal defense. Mark Garver could not represent me due to a scheduling conflict, so by the time I knew the continuance was denied, I barely had enough time to retain another attorney, and I had missed several filing deadlines. Skyping, for example, is allowed in California. No vital signs of physical exam is done. Doctors are supposed to be respectful, compassionate, courteous, and do no harm to their patients and staff, are they not? Larry Mercer, prosecutor for this case called us a mill. Not when I was working. I think to educate the people, and I tried to educate the people and give them helpful suggestions. Larry Mercer did make the point that we were very busy. He said he got false documents, plural, on the Friday afternoon prior to the Tuesday and Wednesday hearing. My attorney, Gary Thielander, had told Larry Mercer that I couldn't find Officers Woolsey and Hatzenbuehler in our San Jose records. I supposedly saw them as patients and wrote their recommendations in our San Jose clinic. That was not a document, it was not plural, and it was not false. Within one working day of that revelation, Attorney Ralph Hughes, who interviewed me for 2 hours...
Sorry, I need you to slow down while you're reading, just a little.
Dr. Altchek, we have our reporter taking
Yeah.
everything down, and sometimes when we read, you speak a little faster, so just try and slow down.
My attorney, I supposedly saw them as patients and wrote their recommendations in our San Jose clinic. That was not a document, it was not plural, and it was not false. Within one working day of that revelation, Attorney Ralph Hughes, who interviewed me for 2 hours and 5 minutes and wrote the 100-page report, announced he will not go to court, and he didn't, giving no reason. Also, within one working day, Officer Lindsay Brearley, a witness for the prosecution, requested the defense excuse her from the hearing. My attorney refused. She did not show, giving no reason, but she did write a declaration. She wrote that she is an undercover officer and that she got her medical marijuana MMJ recommendation from me on July 21st, 2015. She wrote that she requested the cultivator's license, that one patient can grow 99 plants per year without indoor lighting, or 396 plants per year with indoor lighting. I said I don't write the cultivator's licenses, but on Saturdays other doctors would write it. Officer Brearley revealed her name, real name, and alias. She said nothing about getting DDHN's approval to record the visit, or that she recorded it, or that it was lost in the download. Ralph Hughes wrote in his report that with approval from DDHN, she recorded the visit, but it was lost in the download. Those stories don't match. Officer Iriyama was another undercover officer who came in for his recommendation and got it from me on March 3rd, 2015. He said DDHN approved his recording the visit, and he did record the visit, and it was already transcribed. At the end of the office visit, I asked if he had any questions. He did not, which shortened the visit. He said the patient before or after him took about 10 minutes. He said he had recorded about 30 undercover visits and none were lost. Officer Woolsey came to court and testified that he and Officer Hatzenbuehler, who did not come to court, were undercover agents who were seen together by me on June 27th, 2014, and given their medical marijuana recommendation by me. He said that 1.5 years later, DDHN asked him to write a letter about this visit, which he did. Ralph Hughes supposedly didn't receive this letter until 2.5 years after the alleged visit. This letter on page 68 of the report does not have Officer Woolsey's name, signature, or date of the letter. This letter is hard to believe. Read it for yourselves. Officer Woolsey said that he and Officer Hatzenbuehler used aliases which he adamantly refused to reveal. Officers Brearley and Iriyama revealed their aliases. Why didn't he? The defense had and has no way to determine whether Officers Woolsey or Officer Hatzenbuehler ever came in to the San Jose clinic. The question is, did they? Take into account, besides what I just said in the last 8 sentences, that Ralph Hughes and Lindsay Brearley bolted one day after it was revealed that I didn't find Officers Woolsey and Hatzenbuehler in our records. We don't even have proof that they had aliases. The next patient was identified only as RS, whose recommendation I wrote. He signed that he took no meds, did not have schizophrenia or bipolar disorder, and that everything he wrote was true. Someone named Claudia, apparently his mother, wrote that he has schizophrenia and was taking psych meds for it. She wrote that due to using the medical marijuana, RS stopped his psych meds, which caused a psychotic break, requiring admission to a psych facility. Claudia later wrote that RS stayed on his psych meds and it was the marijuana alone which caused his psychotic break. Neither RS or Claudia came to the hearing. We have no proof that he has schizophrenia, that he took meds for it, that he had that psychotic break, and so on. It looks like DDHN never got court orders for Officer Iriyama or Brearley to record. They were not included in the 100-page report, period. My Title III Fourth Amendment right for privacy has apparently been violated. 243 years ago in 1775, bear with me, Patrick Henry first delivered his famous speech, which ended with, "I know not what course others may take, but as for me, give me liberty or give me death." The colonists had to deal with, among other things, writs of assistance that they housed the British for free. 1 year after Patrick Henry's speech, the Declaration of Independence was signed and the American Revolution had begun. Don't underestimate the importance of that speech or the Fourth Amendment, privacy. Maybe Ralph Hughes and Officer Brearley not only knew that Officers Woolsey and Hatzenbuehler never came to our clinic, but that DDHN never got court orders for Officers Iriyama and Brearley to record if she did. What else does Ralph Hughes and Lindsay Brearley know about this and don't want to say? There were supposedly 4 undercover agents. There could have been more or less, and none were seriously ill, like stage 4 ovarian cancer, intolerance to the chemo, nausea and vomiting, and so on, who most doctors and I would probably spend more time with. The prosecution can send in as many undercover agents as they want and mention only who they want. I repeat, the prosecution can send in as many undercover agents as they want and mention only who they want. How scientific and how fair is that? Try sending the amount of undercover agents that they really send into me into every doctor in California. Good luck with that one. In 2010, I signed a stipulated settlement, which is on the Medical Board of California website, that I agree that the allegations against me, if proven at a hearing, constitute grounds to discipline my California medical license. There was no hearing, so nothing was proven. Why do I bring this up? Ralph Hughes wrote that in 2010, I was put on probation for overprescribing and not doing complete exams prior to writing controlled substances. This is false. Larry Mercer wrote, I learned nothing from my previous mistakes. What mistakes were proven? This is false. A.L.J. Cox wrote that I was put on probation because I wrote controlled substances without doing a complete exam. This is also false, but from the judge. Dr. Palanasamy was the prosecution's so-called expert witness on medical marijuana. He had multiple glaring shortcomings, including his responses to questions at the hearing. In the defense's written closing arguments from the 2018 hearing, we summarized some of his glaring shortcomings, which I ask you to reread. A.L.J. Cox wrote, Dr. Palanasamy's training and experience prove he can critique an MMJ doctor. I say that statement is either half false or completely false. No proof of his MMJ training, if he had any, was presented at the hearing. His experience was supposedly writing at least 2 or 3 MMJ recommendations a week. Experience in this field was evaluating patients for MMJ recommendations only 5 days a week, year after year, with instant electronic verification 24/7, which he did not have, as I did, for 9 years and 10 months. There were many other doctors who did just exactly that, usually for fewer years. Why not recruit one of them as an expert witness for MMJ? I think everything Dr. Palanasamy said should be thrown out or seriously discounted, but I have to go with what he did say. He said I had simple departures from the standard of care. Todd Mikiura, a dedicated and beloved physician, now deceased, was used as a precedent to this case. His expert witness said he had extreme departures. For alleged moving violations, if you go to court and the officer who wrote that citation does not usually get off. Ralph Hughes wrote the 100-page report and didn't show. Officer Brearley didn't show. Virtually every ruling by the judge went against me, including not giving me the continuance and allowing Officer Woolsey to remain a witness and the trial to
Dr. Altchek, you have 3 minutes.
Thank you. Including not giving me the continuance and allowing Officer Woolsey to remain a witness and the trial to continue without Officer Woolsey divulging his or Officer Hatzenbuehler's aliases. And why did ALJ Cox write that I can't supervise advanced practice nurses and physician's assistants in a so-called order, which was non-adopted? Nothing is in the record that I ever supervised them. Check the record, please. I said when asked that I didn't remember anything I learned. I'm going to skip that because I want to make sure I could finish. That was 8 years ago. Larry Mercer said, all attempts to rehabilitate me failed. What were they trying to rehabilitate? That statement is false. And by the way, it's very unlikely I will write MMJ recommendations in the future. There has been legal recreational marijuana in California since January 1st, 2018. So what have I learned from this ordeal? My main takeaway, chart well using the SOAP format. About sanctions, I believe all charges against me should be dismissed. If you need to, give me something. Please send me to a course. Probation will make it very difficult for me to be hired as a doctor. Please reread page 68 of Ralph Hughes' report. Please reread the defense's closing arguments from the January 2018 hearing. Please reread the 2010 stipulated settlement on the medical board's website. And please reread the 2014 proposed decision and order, which was adopted, also on the medical board's website. Dr. Dasa and Dr. Raby said good things about me. For example, of the 8 potential witnesses for the prosecution—
You have 1 minute.
Thank you. 5 were no-shows at court. Ralph Hughes, who wrote the 100-page report, these are the people who didn't come. Ralph Hughes, Officer Brearley, R.S., his apparent mother Claudia, and Officer Hatzenbuehler. 3 witnesses showed at court. Officer Woolsey, but we cannot verify that he was a patient at the clinic. Dr. Palanasamy, but we think his credibility is very suspect. And Officer Iriyama. That's 1 credible witness who showed out of 8 potential, and he was undercover. Was this even enough to finish the hearing? Why did Ralph Hughes and Lindsay Brearley bolt? What are they not saying? It's like this case was built on quicksand. Sincerely and respectfully, Mark Altchek, MD. Thank you.
Thank you. Mr. Mercer?
Thank you, Your Honor. As the panel members are aware, we did submit a written argument. I don't want to repeat what's in the written argument that we submitted. Therefore, to save the panel time, I will address whatever questions you may have for me with regard to the issue before us, which is whether or not the penalty is necessary to protect the public.
All right, thank you. Perhaps, do you want questions at this time or at the end?
I'll
Do
leave it
the
up
panel
to the
members have any
panel.
questions right now? No, okay. All right, thank you. Then, Mr. Thielander, were you going to make the closing argument, or is Dr. Altchek?
Well, I have nothing to add. I'll leave it to my attorney to say anything if he wants.
I'm sorry. Mr. Thielander, are you going to make the argument, or do you have any
Very
further argument?
brief comments to wrap this up.
Okay.
Quite frankly, it's one of the things that concerned me during the presentation of the argument, and the thing that we've made clear is I too requested a continuance of the hearing when I came on board, and I had to request a continuance so I wouldn't operate below my standard of care. The fact of the matter is part of the reason Mr. Garver couldn't present the defense was a scheduling conflict, in addition to which he was uncomfortable going forward without what he felt was professionally sufficient time. I've got a little bit more experience in the saddle as a criminal defense attorney and as a civil attorney, so I was willing to take on this case with the admonition that I would be making a motion to continue. And what's of greatest concern, and I would like to focus on this, is that the Officer Woolsey and the Officer Hatzenbuehler, neither of them came to Dr. Altchek to do an investigation of Dr. Altchek for going below the standard of care. They both came to him 2.5 years prior to this hearing for the express purpose of getting medical marijuana cards to serve them in their undercover work. As a 17-year prosecutor in the state of California, I would never utilize the testimony of an investigator who had merely spoken to an individual without a directed investigative plan. You have a target, you have a subject, and you address your questions and you address the things that you try to elicit from that target for that subject matter. In this case, they went for another purpose. Apparently, in a hallway, they mentioned to District Attorney Chin that they had, in fact, spent time with Dr. Altchek some 1.5 years earlier at that moment in time. And Deputy District Attorney Chin asked them to present a letter about their experiences, which, under cross-examination, Officer Woolsey admitted he drafted 1.5 years after the events. The problem with his testimony is, when you asked him questions on cross-examination, the most frequent answer was, I don't recall that specifically. And there is an inherent problem in that type of investigation. The fact of the matter is, we are all here gathered today to determine whether or not Dr. Altchek is going to be allowed to retain his ability to practice medicine in the state of California. I would ask the court to seriously consider granting him the opportunity to go on to probation, to have the coursework that's appropriate, and the recognition of his 4 years of medical service to this community, the state of California. And with that, I would rest. Thank you.
Thank you. Did you have anything further, Mr. Mercer?
Briefly, Your Honor, with regard to the undercover police officers, that's been raised by both the respondent and his attorney as a basis that for finding the decision infirm. However, I would point out that on page 9, paragraph 6, the administrative law judge did not rely upon that undercover visit for her decision. The reason was because we would not disclose the undercover operative name for the officer for officer safety, and as a result we did incur the evidentiary sanction that his testimony was disregarded. However, the most compelling testimony in this case came from Dr. Altchek himself, and that's cited in our written argument, wherein he indicated he did no physical examinations, acquired no prior medical records, did none of the things that this board has promulgated as the standards for recommending medical marijuana since 1997. After Prop 215 passed, the board published in its action letter a statement to physicians that the board expects physicians to do the same things in recommending medical marijuana that they do for recommending any other kind of medication or treatment. And that is the basis for this decision, and it should be upheld. There's some disagreement between the respondent and his counsel as to whether or not he would be willing to be on probation. We honestly believe that this case calls for revocation because he has not only not done what he should have done, he has said that he would not do what he should have done at this hearing. Therefore, there is no basis to put him on probation. However, it is within this panel's authority to put him on probation should you deem that consistent with the public protection. If that is the case, then we would ask that there be an objective evaluation of this physician via a clinical assessment program, and that there be a practice monitor responsible for reporting to the board that he has at long last brought his practice within the standard of care. Thank you.
Thank you. All right. At this time, I'll invite the panel members if they have any questions. Yes, Dr. Hawkins?
Thank you very much. So I have a statement, then I have a question. So Dr. Altchek, prior discipline in 2010 for improper prescribing without a prior exam resulted in discipline that included prescribing practices course and medical record keeping course. Now, related to the current accusation, you volunteered you did not remember the medical practice, the medical record keeping course, or the prescribing practices course. My question is, excluding prescribed marijuana, since marijuana is now illegal in California, how do you envision the type of practice you would have? What would be your practice going forward? And I may have a follow-up question depending on how you answer that question.
First of all, you gave a reason for why I was put on probation. I agreed. I signed in the stipulated settlement in 2010 in June that if the allegations against me were proven at a hearing, I am subject to some kind of sanctions. I don't remember how it went. But there was never a hearing. Nothing was ever proven. So okay, now, I went to the courses in San Diego, 2010, and it was just about all a review. I mean, nothing stood out as anything I particularly remembered. It was worth going to because I learned, I reviewed things. I was able to hear some things that clicked, and I remembered, so sort of underlining what I believe I knew. And as far as my practice, I don't know why I can't just get a clinic job. But I believe that the probation is going to be a problem to getting just a basic clinic job. But that's what I'd like to do, is just go back to, I work for the state of California Department of Corrections, and mainly I did ER and I did walk-in clinic. And so I dealt with hypertension, diabetes, arthritis, you name it, angina. And that's what I'd actually like. Did that kind of answer things?
Well, it's your answer. So, as a practicing physician, I think that we develop a standard of practice that we tend to use over and over again. And one of my questions is, since I don't know if you even know how to take a complete history and physical because of what you've been doing the last several years, my concern is whether you would be able to provide the type of care that's required for the citizens of the state of California. And although you stated that you indicated you really didn't remember very much about the courses because this is what you did anyway, I'm trying to get reassured that you actually really know how to do a complete history and physical, how to obtain medical records, how to do what's required to evaluate and treat patients, which is what we're responsible for doing when we license physicians in the state of California.
May I make one clarification? What happened, the discussion about what he did or didn't remember from the coursework, the administrative law judge asked him the question, what do you remember from the coursework? And he answered off the cuff, well, as I sit here right now, I don't remember anything in particular. He then went on to explain that he found the coursework to be valuable, and he noted that for time it helped him to refocus on his SOAP requirements, etc. That's what was germane to that. And with that, I'll allow him to answer your question.
And then to clarify the answer to my question, you envision providing care to the average citizen in a clinical setting. Is that accurate in terms of what you envision, the type of practice you would have going forward if you have a license?
Most likely, but there are other areas of medicine. I'll tell you one that I'm particularly interested in. It's A4M, the American Academy of Anti-Aging, and which I'm a member of, which I went to in Las Vegas twice, their big conference in December. And they're pretty much, their bread and butter is replacing the hormones in the people, the over 40 crowd, whether it be progesterone, progesterone and estrogen, mainly for the women, testosterone for the men. I'd like to do that. But I'm probably going to end up, if my license is not, if I come out of this more or less okay, I'm all for doing courses. But what I think I've done a lot of just walk-in clinic work, and I think it'll come back to me pretty quickly. In fact, as I did my medical marijuana practice, the people were giving me diagnoses, and I had to be up on them to really make some sense and give them some helpful ideas quickly about it. Sure, they're going to go back to their doctor, but maybe there's a dietary idea that I have in mind. I'm pretty much against milk in general. If you have, for example, autoimmune diseases like multiple sclerosis. I've learned, I learned a lot in the last 10 years. There's Joe Mercola. He has the number one alternative. Now, I don't know if I should say this, but I started, and I should probably, well, it's too late now. He has the number one alternative website in the world, and he has good ideas. And listening to him was a good review for things. And I listened to almost every interview he had with all his different doctors who wrote books. They were kind of promoting their books, but also there was really good information.
Thank you very much. I don't have any other questions.
All right. Ms. Wright, you had a question? No. Okay. Anyone on this side? Yes. Mr. Wormuth?
I found that you were spending a lot of time talking about the findings of facts in the proposed decision. Speaking for myself, I don't have a lot of problems with the findings that the ALJ made. My personal objection, I guess, is the level of discipline. And reading through the record, one of the things that stuck out at me was when you were testifying about the adequacy of the histories and examinations that you took in order to make your recommendations for medical marijuana, and I believe at one point you said that you thought that those were adequate. My question is, if we did place discipline short of revocation, do you maintain that that level of history and examination is sufficient going forward?
No, definitely not. Two different games here. One is a busy medical marijuana clinic where to give the recommendation, you pretty much can give it for insomnia and nothing else, headaches and nothing else, anxiety and nothing else, back pain and nothing else. Given that, I think it was fair to give the recommendations just listening to the people. Working in a clinic setting, I'm going to have peer pressure. There's going to be peer review. I'm going to be given, I don't know what it is, would depend on the clinic, but maybe 20 minutes for an average exam, maybe longer for the first time. And I would be much more thorough about it. I would order labs. I would check the labs. I would record the lab results and record how they responded to whatever medicine I gave them. Maybe change it if if they hadn't had a good response. So definitely, working in a clinic setting, I would spend much more time and be much more thorough. And I would go back to my SOAP notes, which is what I did as a resident. It was mandatory as a resident. So, did I about answer that?
Yep, that's fine. I would like to ask, though, you sort of brought it up in your testimony, but do you have any comments about, further comments about the level of discipline that you think appropriate?
I do, and I would focus on the issue of what Dr. Palasimi found. In every instance where he made a finding, and quite frankly, you're correct. You haven't articulated, but I do have issues with some of the evidence, and my concern is it's hard to filter through what really affected the administrative law judge's decision. But having said that, I would concentrate and focus on the fact that whichever one of the patients Dr. Palasimi investigated, he found a simple deviation, not an extreme deviation. And I think that as to the witness Iriyama, who I found to be completely credible during his testimony and the way he presented himself and the way he conducted his examination, as to what Iriyama described and what Palasimi was able to review there, because there was a chart to review, he did find, again, a simple deviation. And I think a simple deviation requires something less than the ultimate sanction.
I'm sorry, was the question directed to me?
Yes, it was, actually.
Thank you. With regard to that, I would point out from our written argument that this is a probationer, past probationer, who came to the board in 2014 and said, I've learned my lesson, I'm ready to be off probation, and the board granted him early termination. And just a couple of years later, we have 3 undercover officers who are able to go in without any difficulty at all and get him to essentially give a recommendation without engaging in the basic practice of medicine. At the hearing, he had the opportunity to say that he would change his practice. He didn't say that. He said that what he did was right, that he didn't need to get prior medical records, that marijuana never killed anybody, and that he could prescribe it without a physical exam, just an eyeball exam. And for that reason, we point out that the law is pretty clear that while the board has an obligation to rehabilitate physicians where it is possible to do so, where in fact the physician has been given ample opportunity and has failed, then at some point the board has to say, what is the public purpose in keeping this doctor in practice? We submit that there really isn't a basis to keep him in practice. The board has been promulgating prescribing guidelines now since 1994. We have a physician who blithely ignored them, said he may have read them, remembered nothing about them, and we question what message we're sending to the public by saying, all right, twice now he has said, I didn't do what you say is required to prescribe, and yet we're going to continue him on yet another probation. At some point, there has to be a moment when we say the board has done enough and now it's time to protect the public and have physicians who actually do obtain a full and complete history, including an addiction history, that do take physical examination, that do acquire prior records, that do laboratory tests on what are potentially serious conditions. These patients, to the extent that they offered medical self-diagnoses, some of them were serious and they were not explored. Nothing was done for them. Do we really want to have physicians out there who hear that their patient thinks that they have something seriously wrong with them and then does nothing? We believe that revocation is the right decision.
Dr. Lewis?
Can I just add a little bit?
No,
Okay.
we're going to move on, okay? Otherwise, it'll just keep being repetitive. And we're trying to get you to be concise. I think sometimes your own worst enemy is because you go around in circles and you're not using your counsel to help guide you. So when a question is asked, please just respond to the question. Otherwise, you're bringing up things that have nothing to do with the case. I will make an side comment is that your Academy of Aging or Anti-Aging is not a board-recognized academy, and it's fraught with charlatans who have instant cures. And so all of a sudden I see you're into marijuana, and then you make this comment, well, I may do something with biologicals and hormones. Well, some of them do work, but it worries me that you're taking a whole nother group of susceptible people and putting them into your practice. So that is my side comment. Now, Dr. Altchek, do you know the standard of care for marijuana recommendations? And if you do, could you tell me the standard of care that's currently in effect?
I don't know if it's currently in effect, right?
Yes.
I mean, there's no medical marijuana. Well, all right.
The standard of care,
All right,
what
I can
you
tell you.
have to
I
do
can
as a
answer that question. I
physician.
don't really think it's being done now, because in California, all right, so what
I'm
it is
asking you a question. Just
I know.
answer that.
So
You'll be most helpful for yourself if you answer it.
we're supposed to get information from from some primary doctor that they may have, if they do, and do a thorough exam.
It worries me that you cannot be forthright and say, I need to do this, this is required. Sometimes you don't have to do lab tests. You know, lab tests are not always the answer. So what would you do? Patient comes in the room, what's expected of you to do for the standard of care? You should be able just to go, this. You know, you've studied it. So let me hear that, please. Convince me.
For medical marijuana or in general?
We're talking about the medical marijuana issue that kind of got you here.
I'm supposed to take a thorough history and physical, talk to or get information from the doctor, their doctor, if they have one, accumulate some additional information. That's all that I know.
Okay, that's all that you know. Okay, well, it's your answer is your answer. Let's see. Are you working in a clinic? Are you in a situation where you're working now?
I'm not working now.
Not working now. And if you, as we asked previously, if you were given a probationary license, where would you work? What is your...
Well,
I know you've answered it, but I
most
just need to
likely
hear it.
it's going to be at a clinic.
A clinic
A medical clinic.
A medical clinic.
General medical clinic.
Okay. You know, if we have a free and clear license, you know what that allows you to do? Go work anywhere in any specialty if you can get a job. So free and clear is a little difficult to make that leap, so to tell you. So I don't have any other questions. My one thing was that, do you understand what it is to do standard of care exam? So, but thank you for your response. I have no further questions.
All right. Dr. Yip, did you have a question?
I read some of the evidence that your point of patient case eyeball exam. In your clinic, they will work at in intake form. Do you ask the patient, female patient, if they're pregnant, their last menstrual period?
Is this for the medical marijuana or
For the medical marijuana.
Well, I didn't ask every female patient if they're pregnant. I mean, even the fertile ones. If they were pregnant, I had one lady who was quite pregnant, never had the medical marijuana, obviously pregnant, and I asked her and she said yes, or something like that. And I didn't give her the recommendation.
Thank you.
Not that there's any proof that medical marijuana is harmful to a pregnant lady, but I was just too uncomfortable about it. I said, come back after the pregnancy.
Thank you.
Or go
Thank you.
elsewhere.
Thank you. Do we have any other questions from the board? Okay. All right, at this time then we're going to go into closed session. We're off the record.